What if the man behind one of America's most infamous family murders somehow walked free? Think about that for a moment. A man serving multiple life sentences. A case the world believes is sealed forever. Yet behind the concrete walls of Dodge Correctional, behind the court rulings we think we understand, there are whispers, rumors, legal shadows. Each one is asking a question most people are too afraid to even consider. Is there any scenario, any loophole, where Chris Watts could step outside a prison gate again? It sounds impossible. It should be impossible. But the truth is stranger than comfort allows. Because buried in the U.S. justice system are obscure appeals, technical legal failures, procedural cracks, and rare case precedents that have overturned sentences far more straightforward than this one. And recently, new conversations, new claims, new online filings have reignited the debate. Tonight, we're going deeper than headlines ever did. Into the court documents, the sentencing structures, the hidden legal mechanisms, and the very few, but very real, pathways people never hear about. By the end of this video, you will understand exactly what can happen, what cannot happen, and the chilling truth about Chris Watts' legal future. Subscribe to Dark Crime Casefiles, where no crime stays in the dark. To understand why this question matters, we have to go back, briefly, to the moment the sentence was handed down. Chris Watts received multiple life sentences. No possibility of parole. No second chance is built into the structure of his punishment. In Colorado, a sentence like his is rare. It is reserved for the most severe, most unforgivable crimes, the kind the justice system wants sealed forever. Most people hear life without parole and assume the story ends there. No appeals. No openings. No future beyond a prison cell. But the truth is more complicated. Even in cases like this, the legal system has layers the public rarely sees: appellate reviews, federal avenues, constitutional challenges, clerical technicalities, and the slim possibility of procedural failure. And that brings us to the question almost no one dares to ask out loud. Could Chris Watts ever get out? Tonight, we break down the legal reality, not rumors, not fantasy, the actual mechanisms that determine whether a life sentence can ever be touched. So let's break down exactly what Chris Watts is serving, because the reality of his sentence is far more structured and far more complex than most people realize. Chris Watts isn't serving one life sentence. He is serving 5. Each one stacked, one after another, in what the courts call consecutive terms. This means that even if one sentence were ever questioned, the others would remain locked in place like steel doors behind him. He also received additional years for tampering with the bodies, years that don't even begin until after the life sentences conclude, which is another way the court ensured there would never be a pathway back into society. And then there's the phrase everyone recognizes but few truly understand: life without the possibility of parole. In many states, life still has an eligibility date: 25 years, 40 years, sometimes even 50. But Colorado's version of life without parole is absolute. There is no parole board to petition. There is no future hearing. There is no built-in safety valve that allows an inmate to prove they've changed. It is as final as the legal system allows. And that's exactly why this case is so debated. Because when a sentence is this airtight, the only ways it can ever change lie outside the normal path. Not through good behavior. Not through prison programs. Only through technicalities, appeals, or extraordinary intervention, each one rarer than the last. Understanding this structure is the key to understanding the real question ahead. The parole is impossible. Then what would it actually take for Chris Watts to walk free? That's where we're headed next. If Chris Watts' sentence is so airtight, why do so many people believe he could somehow get out? It comes down to 3 powerful forces: misinformation, misunderstanding, and tiny fragments of legal truth that get twisted into something they're not. First, Every few months, posts start circulating online. Claims that Chris is filing new motions. Claims that Colorado is reviewing his case. Claims that he's preparing a mysterious appeal. Most of these stories erupt from social media, misread documents, or speculation from people who don't fully understand what's actually happening in the legal system. Then there's the confusion. Many true crime followers assume that every life sentence eventually leads to a parole hearing. They don't realize that what's sentence is the strictest version possible, not one opportunity for review. So when people hear the word appeal, they imagine freedom might follow. But the third reason, the reason these rumors never seem to die, is because buried in the American justice system, there are rare situations where even the harshest sentences have been re-evaluated. Not wiped away, not forgiven, but revisited, usually because of constitutional violations, procedural errors, or legal changes that impact how a sentence was applied. It's these rare cases, these exceptions, that fuel the question, if it happened for someone else, could it happen for him? That tension between the impossible and the technically possible is what keeps this conversation alive. And now that we've cleared the misconceptions, we can finally examine the truth, the actual legal pathways, the ones grounded in law, and the ones that are completely off the table. Let's move from rumor to reality, and the reality is more procedural than dramatic. If you're asking, could Chris Watts appeal? The short answer is yes. In the literal sense, there are legal avenues. The long answer, the one that matters, is far more restrictive and, in practical terms, highly unlikely to lead to freedom. First, understand the landscape. Appeals come in two basic flavors: direct appeal and post-conviction relief, state and then federal. Each has its own rules, timelines, and legal hurdles. Direct appeal is the automatic route after a trial. If a defendant is convicted at trial, appellate courts review the record for legal errors, improperly admitted evidence, judicial error, and incorrect jury instructions. But Chris Watts didn't go to trial on the murder counts in the ordinary way. He pleaded guilty as part of a plea agreement that avoided the death penalty and resulted in multiple consecutive life terms without parole. That fact dramatically narrows the scope of a direct appeal. When a defendant pleads guilty, they generally waive the right to most appellate claims because the plea itself is an admission and, usually, an agreement not to contest the conviction. So what can be attacked after a guilty plea? Limited things: the voluntariness of the plea, the validity of the plea colloquy, did the court properly establish that the plea was knowing and voluntary, and jurisdictional defects, e.g., if the court lacked authority to accept the plea. Those are narrow windows. Challenging them requires showing the plea was coerced, that counsel was ineffective at the plea stage, or that some constitutional defect infected the process. That's a high bar. That brings us to post-conviction relief at the state level. These are collateral attacks, petitions that sit outside the direct appeal. The most common grounds here are ineffective assistance of counsel, newly discovered evidence, Brady violations, suppression of exculpatory evidence, or constitutional claims not apparent on the record. State post-conviction petitions can reopen issues that direct appeal can't, but again, procedural rules and filing windows strictly limit how and when these claims can be made. Many claims are time-barred or procedurally defaulted if not raised at the right time. If state courts deny relief, the next step is federal habeas corpus. This is often portrayed as a federal lifeline, but in reality federal habeas is tightly constrained. Under the current federal statute, habeas petitioners must show that the state court's decision was contrary to, or an unreasonable application of, clearly established federal law, or that it was based on an unreasonable determination of the facts. In plain terms, you must show not merely error, but that no reasonable jurist could have reached the state court's conclusion. That is a steep, technical standard and one of the key reasons federal habeas relief is rare. Two practical problems bite here: procedural default and EED. Procedural default means if a defendant failed to raise a federal claim in state court at the proper time, federal courts will generally refuse to hear it unless the petitioner shows cause and prejudice, or actual innocence. The Anti-Terrorism and Effective Death Penalty Act, AEDP, further tightens the review, imposing a one-year statute of limitations for filing federal habeas from the date the state conviction becomes final, with few exceptions. Missing deadlines or mishandling procedural steps can doom a claim before it's ever heard. What about new evidence? Incredibly compelling, newly discovered evidence can reopen cases, but the evidence standard is exacting. It must be something that was not available at the time of trial or plea, and that would probably have changed the outcome at trial. For many high-profile cases where the chain of forensic and digital evidence is intact, phone records, search history, physical evidence, producing evidence of that magnitude after conviction is difficult. Another potential ground is ineffective assistance of counsel, most commonly argued when lawyers miss constitutional issues or fail to investigate. Successful IAC claims require showing two things: counsel's performance was deficient, and the deficiency prejudiced the defense in a way that likely changed the result. That is a two-part, often fact-heavy inquiry, and success is not common, especially when the record shows the defendant entered a comprehensive plea after consultation. There are also rare, extraordinary routes. For example, a successful constitutional challenge that changes the legal foundation of the conviction, or newly surfaced proof of prosecutorial misconduct so serious it undermines confidence in the outcome. These situations happen, but very rarely, and nearly always require extraordinary factual development or legal change. Even if a court were to grant relief, vacating a conviction or sentence, the result is not automatically freedom. Typical remedies include vacatur and remand for a new trial or resentencing. In a case like Chris Watts, where multiple consecutive life terms were imposed, vacating one count may leave other life terms standing. In short, even a partial win often leaves the ultimate practical outcome unchanged: continued incarceration. Finally, there are non-judicial avenues that people sometimes cite: executive clemency, pardons or commutations, from a governor or the president. These are political acts, not legal rights. They're rare and discretionary, usually reserved for cases with compelling rehabilitation evidence, clemency campaigns, or clear miscarriages of justice. For high-profile family annihilation cases, clemency is essentially a political non-starter. So where does that leave us? Legally, there are pathways: direct appeal, extremely narrow after a guilty plea; state post-conviction proceedings, possible but procedurally constrained; federal habeas, available but subject to EEDPA's restrictive standards; and, outside the courts, executive clemency, extraordinarily unlikely. Practically speaking, none of these routes offers a plausible path to freedom in most cases like this one, especially given the plea structure, the consecutive life terms, and the weight of the evidence. In short, the system contains mechanisms that theoretically can alter even the harshest sentences, but in practice, and given this case's facts and legal posture, the chance of those mechanisms producing freedom is vanishingly small. Even after every legal path has been accounted for, the question remains: could new evidence ever change Chris Watts' fate? In theory, the law allows for post-conviction claims based on newly discovered evidence, facts that were unknown at the time of trial or plea, facts that could have reasonably altered the outcome. But the threshold is extremely high. Courts demand that such evidence be not only new but also credible and compelling enough to challenge a verdict that has already been finalized. In Watts' case, the forensic record is extensive. The digital trail, phone records, GPS data, and other electronic evidence aligns with the timeline investigators reconstructed. The physical evidence corroborates the confession he gave as part of his plea deal. That's why the possibility of truly new evidence is so remote. Still, theorists online and some armchair analysts speculate. What if an unknown witness comes forward? What if undiscovered digital evidence emerges? Could a previously unexamined legal or forensic error provide a crack in the system? Legally, these scenarios are acknowledged, but they are extremely rare. Even in cases where new evidence has reopened convictions, the courts require not just plausibility but near certainty that the evidence would have produced a different outcome. And when multiple life sentences are stacked consecutively, even a partial legal victory often leaves the majority of the sentence intact. There is also the human factor. The courts are unlikely to overturn a plea agreement without overwhelming proof of coercion, deception, or constitutional violation. And with Watts' plea extensively documented and reviewed, the window is almost entirely closed. In other words, while the concept of new evidence keeping hope alive makes for compelling speculation, the reality is that the chances of it freeing Chris Watts are vanishingly small. The courts are designed to prevent reversal in cases where the legal and evidentiary record is strong, and this case is the textbook example of that principle in action. Yet the idea persists in public discourse. The notion of a loophole, a hidden flaw, or an overlooked technicality fuels curiosity, and that's why this story continues to grip the true crime community even years after the sentencing. Beyond the statutes, filings, and legal technicalities lies another question that intrigues both the public and criminal justice experts. Could Chris Watts' behavior behind bars ever influence his sentence or legal prospects? In most cases, an inmate's conduct can have practical effects, such as privileges, prison transfers, or participation in programs. But when it comes to life sentences without parole, the impact is largely symbolic. Demonstrating rehabilitation or remorse rarely changes the legal outcome once a plea agreement is in place and the sentences are consecutive and absolute. That said, psychologists and prison observers continue to watch him closely. Reports describe a man who is quiet, withdrawn, and avoids drawing attention. Guards note his compliance and apparent routine acceptance of prison life. Fellow inmates refer to him cautiously, often with a mix of contempt and curiosity, aware of the notoriety that surrounds him. These observations may not alter a court's ruling, but they paint a window into the daily reality of a man serving multiple life sentences. Experts argue that prison behavior can, in rare instances, influence executive decisions, like clemency or commutation. But in Watts' case, these avenues are extraordinarily narrow. Any petitions for mercy would face immense public scrutiny, ethical opposition, and political resistance. High-profile crimes like this one leave little room for leniency, no matter how model the inmate's conduct. Still, examining his psychological state and behavioral patterns offers insights into the human side of incarceration, how isolation, guilt, and notoriety shape life behind bars. It shows how the justice system balances punishment, public safety, and rehabilitation, even when rehabilitation will likely never alter the final outcome. Understanding this helps you see the full scope of the case, not just the legal machinery, but the human elements that play out daily behind the walls, quietly observed, rarely affecting the official sentence, yet still feeding public curiosity. By now, we've explored every conventional legal path and established just how unlikely they are to change anything. But let's entertain, for a moment, the most extreme possibilities, the only theoretical ways Chris Watts could ever leave prison. First, the presidential pardon. The president has the constitutional authority to pardon federal offenses or commute sentences in extraordinary cases. But Watts' convictions are state-level, and even federal intervention would face insurmountable legal and political obstacles. Presidential pardons for notorious family annihilators are virtually unheard of. Public outcry alone would make it nearly impossible. Next, a governor's commutation. Governors can reduce or alter state sentences, even life sentences, but such acts are discretionary and rare. In Colorado, clemency petitions must show overwhelming evidence of rehabilitation, extraordinary circumstances, or miscarriage of justice. Considering the high-profile nature of this crime and the public and familial opposition, the political cost of granting clemency is prohibitive. Then, there's the possibility of an overturned conviction. This could occur if courts found procedural errors, constitutional violations, or other judicial missteps. But Watts' plea agreement was meticulously documented, reviewed, and accepted, leaving virtually no procedural gaps. Overturning a conviction in such a case is almost unheard of. Even if one conviction were vacated, the multiple consecutive life sentences would remain. Changes in state law sometimes open new avenues for appeals or sentence reductions. However, Colorado law already reflects the strictest form of life without parole. Any legal shift would have to be unprecedented and retroactively applied, a scenario so unlikely it exists mostly in theoretical discussion. Legal technicalities such as misfiled paperwork or minor clerical errors occasionally result in relief. Yet in this case, every filing, every court order, and every plea document was carefully managed. There is no procedural oversight available that could realistically alter the outcome. Constitutional challenges are another extreme scenario, arguments that the plea violated rights, that laws were applied unconstitutionally, or that some fundamental due process violation occurred. Such claims are extraordinarily rare, and courts have already scrutinized the plea and sentencing. The chance of success here is, at best, academic. Misconduct findings, prosecutorial or judicial misconduct, can sometimes reopen cases. Yet there is no evidence of intentional wrongdoing, withholding of evidence, or misconduct that would undermine confidence in the conviction. Investigators, prosecutors, and the courts have consistently upheld the integrity of this case. Finally, wrongful conviction standards are sometimes invoked in rare, high-profile cases where new, definitive proof emerges. But in Watt's case, the forensic, digital, and testimonial evidence all aligns, leaving no grounds for genuine doubt. The conviction rests on a strong, irrefutable foundation. In short, while the law theoretically allows for extraordinary interventions, the reality is stark. Each of these potential avenues is either politically impossible, procedurally blocked, or substantively improbable. They exist only as hypotheticals, and the likelihood of any of them leading to Watt's walking free is effectively zero. Yet, exploring them is essential to understand the depth of the legal system, the limits of appeals, and why questions about his possible release continue to captivate the public imagination. After examining every possible legal avenue, every hypothetical exception, and every nuance of the justice system, the verdict is clear: Chris Watts will almost certainly never leave prison. The law is unambiguous. His multiple consecutive life sentences without the possibility of parole, combined with the thorough plea agreement, create a structure that allows virtually no room for release. Direct appeals are limited, post-conviction relief is tightly constrained, federal habeas review offers little hope, and executive clemency, whether from a governor or president, is practically impossible given the notoriety of the crime and overwhelming public opposition. Even the most extraordinary, theoretical pathways, overturned convictions, new evidence, legal technicalities, constitutional challenges, exist only in concept. None of them realistically present a route to freedom. The legal, procedural, and political obstacles are simply insurmountable. It's important to state this with clarity and respect. This verdict is not about speculation or personal judgment. It is about the law, how it functions in one of the most infamous family annihilation cases in modern history. The justice system has effectively ensured that Chris Watts' sentence will be carried out in full, without exception. Understanding this finality is sobering. It reflects both the power and the limits of the legal system, and it underscores the absolute consequences of crimes that shatter lives and families. As we reach the end of this examination, the reality stands undeniable. Chris Watts' life sentence is absolute, unyielding, and effectively final. Every conceivable legal avenue has been scrutinized, every theoretical loophole considered, and yet the conclusion remains the same. The law has spoken, and justice, in this case, has ensured that the consequences of his actions will never be reversed. But beyond the legal mechanics, there is a deeper lesson to take away. This case is a stark reminder of the human capacity for deception, the fragility of trust, and the devastating consequences that can unfold behind closed doors. It also illustrates the precision of the justice system in handling crimes that shock society to its core. While the law is unambiguous, the psychological, social, and moral echoes of this tragedy ripple far beyond the courtroom. For true crime enthusiasts, legal scholars, and casual observers alike, Chris Watts' case continues to fascinate not because of hope for release, but because it challenges our understanding of human behavior, the limits of rehabilitation, and the power of accountability. It forces us to confront uncomfortable truths about crime, punishment, and society's need for closure. And while the walls of Dodge Correctional may contain him physically, the case itself will remain in the public consciousness indefinitely, analyzed, dissected, and remembered. If this journey through the legal reality, psychological insights, and the chilling hypothetical what-ifs has given you a clearer understanding of one of America's most notorious crimes, remember to support the pursuit of knowledge. Subscribe to Dark Crime Casefiles, where no crime stays in the dark. Because while some cases may be closed in court, Understanding them fully keeps their lessons alive and ensures the stories of the victims are never forgotten.